welcome to Crime in Court. My name is Heather, and this is episode 72? Yes, 72 of the Canton Cover-Up, Commonwealth versus Karen Reed and Turtleboy also. And today we're going to be going over Turtleboy's juror interview, take two. So in previously this week, Turtleboy conducted a second interview with the juror that he did an interview with most recently. So he's done he's done um, three write-ups of juror interviews. So the first two, the first one wanted to remain anonymous, doesn't really, I mean, they said they would talk more, but they didn't want to talk a whole lot about the deliberation process. So they didn't give us a whole lot there. Now, the second juror that Turtleboy spoke to, he gave us a lot more information about the deliberative process and what people are thinking, and even some instances of possible jury misconduct. We'll talk about that throughout this episode. We're going to go over Turtleboy's interview. But up first, sorry, my dog's barking. Up first, we're going to, I wanted to go over with you. This is breaking news that happened this past Friday. Hold on one second. Just always gotta bark. Okay, I have no idea. She, like a truck goes by and she barks. It's like, what? It's just some car driving by. Good guard dog, that's for sure. All right, so this first thing that I want to talk about, we're going to talk about a couple other things besides the Turtleboy interview. So in addition, we're going to talk about this latest breaking news that happened on Friday, and also some information came out about Kevin Albert, the Canton police officer who is the brother of Brian Albert, whose home was 34 Fairview Road. So we're going to go over a little bit of information on him too, but first, let's talk about this incident that happened on Friday. So a Massachusetts State Police recruit, one of the recruits of the Massachusetts State Police was apparently in some kind of training and ended up with severe injuries that he lost his life due to. So we're going to talk about, I'm going to play this clip and then we're going to go over in more detail his injuries. So his name is, why am I blanking? Enrique Delgado Garcia. Enrique Delgado Garcia. Oops, it helps if I unmute it. Here we go.
We have just learned a Massachusetts State Police recruit has died after he was hurt during a training incident at the police academy in New Braintree. This is according to the young man's mother. It's just a tragic development to a story we've been following all day. NBC 10's Jericho Tran is joining us from Worcester, where we're now hearing from family and friends of that recruit. Jericho?
JC, absolutely devastating news. We were speaking with family and friends, and there were just tears. They say that trainee's name was Enrique Delgado Garcia. He was just 25 years old. I want to give you a look at who his family and friends are remembering right now. This is Delgado. Family members tell me becoming a Massachusetts State Trooper was his dream. They told me that he was injured during a boxing exercise at the Massachusetts State Police Academy in New Braintree on Thursday. But family members have their doubts. They say Delgado's injuries were not consistent with what he would have sustained during a training exercise. They say he had missing teeth, his neck was broken, brain injuries, and contusions all over his body. We spoke with family and friends just moments ago.
I know you would have shined. You would have been the best state police officer there. I feel like that's why what happened to you happened to you, and it sucks. I'll miss you.
Absolutely devastating moments right there. Now, Delgado was training for 3 months. He only had 2 weeks left. We did reach out to the Massachusetts State Troopers, and we still have not heard back. In Worcester, Jericho Tran, NBC 10 Boston.
Yeah, no response from the Massachusetts State Police. So Ay, ay, ay. There's just more and more problems. So I want to spread the hashtag justice for Enrique Delgado Garcia. All right. So really quickly, I wanted to go over his injuries some more. Okay. So Olivia Lambo, she always has the scoop. I'm going to read her latest X on this, or her latest post on X. All right, so Enrique Delgado Garcia, a 25-year-old recruit at the Massachusetts State Police Academy in Braintree, has died as a result of injuries apparently sustained during a defensive tactics boxing training exercise. What the hell is that? What is a defensive tactics boxing training exercise? So, defending himself, he ended up with broken teeth, a broken neck, and contusions all over his body. However, his family says his injuries are not consistent with what would have been sustained during a training exercise. They say he had missing teeth, his neck was broken. Let me repeat that. His neck was broken. He had brain injuries and contusions all over his body. Friends and family are devastated, and unfortunately, they want answers. Um, a family member said they KILL'd my cousin and they run away like cowards. All he did was study and run. That's all he ever did. So, how on earth does one sustain a broken neck, have missing teeth, and brain injuries from a boxing training exercise? Good question. You won't even hear of those kinds of injuries in the pro boxing and fighting world. It sounds like there's a lot more to this story that the Massachusetts State Police aren't telling. Who's investigating this? Hopefully, it's an outside agency. As we've seen, the Massachusetts State Police don't particularly care about conflicts of interest or conducting real investigations where protocol is followed when the loss of a life of a fallen brother in blue occurs. So, Enrique previously served as a victim witness advocate in the Worcester, I can't say that word, Worcester, Worcester, however you guys say it. I apologize. I'm Chicagoan. All right, so the County District Attorney's Office. According to his family, it was his dream to become a state police trooper. My thoughts and prayers are with Enrique's family and friends. As you can see, they're clearly and understandably devastated. His injuries don't match the narrative, and they're outraged. It's refreshing and commendable to see them demanding answers. She says, on a side note, all of the descriptions and reporting I've seen of what happened to him says things like he suffered a medical emergency during a training exercise, or he became unresponsive in the boxing ring during a defensive tactics training exercise. So, he was in the ring boxing, and now he has lost his life due to some very serious injuries. Typically, suffering a medical emergency includes things like having a heart attack, a seizure, or a severe allergic reaction, for instance. Someone whose neck has been fractured, is missing teeth, and has severe brain injuries didn't do it to themselves. So, someone did it to them. And one doesn't typically sustain such injuries because they, for instance, fainted and fell to the ground, breaking their neck, knocking their teeth out, and causing brain injuries on the way. Those things happen especially if you're physically fighting someone, like, say, in a boxing ring, because that other person did it to them, not, uh, yeah, it's not a severe medical emergency considering that it is. I mean, it is, but it's not in really, it's not just like a strange occurrence. This is, or a freak accident. Somebody did something to him to cause those injuries. So, did he become unresponsive while just standing there doing nothing, or did he become unresponsive because someone knocked him out? Good question. This is very passive distancing language that they use, which is concerning. The MSP use distancing language, making it like, well, he just had an emergency and now he's no longer here, not taking any of the responsibility that it had something to do with one of their own officers doing something. So more to develop, I hope, on this. I hope there's an investigation, not by MSP, obviously, but maybe the FBI. Maybe they're already looking at them. I don't know. But yeah, so prayers and thoughts go out to Enrique Delgado Garcia's family and friends tonight. And yeah, it just shows how stinking corrupt and misleading things are in Massachusetts. All right, so let's get to the main topic of this episode. We're going to be going over Turtleboy's Canton Cover-Up Part 399. Karen Reed Juror says they didn't discuss Brian Albert not coming out of the house or Michael Proctor's relationship with the Alberts. It focused on the text stream, data, taillight, and alcohol consumption. So this is a really good recap of his conversation with the juror. And so this is the juror we just did he just posted recently about and we read through. So it's the same juror, again, the EMT, the male EMT who was very open about some of the things that were going on in the deliberation room. And some of the things were quite concerning. So let's get started reading. All right. So on Friday, I interviewed a juror in the Karen Reed case who wavered between guilty and not guilty on the manslaughter charge. Remember, he said he went back and forth. But who confirmed he confirmed that the jury was unanimous that she was not guilty of homicide in the second degree. However, the interview left me even more questions, so the EMT agreed to sit down with me again on Tuesday and answer even more questions. His answers give us a lot of insight into what these 12 people were discussing as the world waited on a verdict. It was an eye-opening interview that showed me and many others the dangers of Karen Reed putting her fate in the hands of 12 strangers. The guilty voters completely disregarded testimony that the general public thought was critical and instead almost exclusively focused on three things. Here is a summation of our interview as I took notes while we were speaking. All right, so Turtleboy asks, what do you think reasonable doubt is? Was the definition discussed during deliberations? And this is a good question because it was never really defined. It was never really defined throughout. Usually it's defined in closing arguments, especially the defense will say, any doubt, if they didn't prove this and you're still questioning the theory, which is what they did, then that's reasonable doubt. And if you're not totally on board with the state's theory, that's reasonable doubt. So they needed to talk about that more. However, they were handicapped because Judge Bev only gave them an hour each to do their closings. So um, Alan Jackson, his name escaped me for some reason. I don't know why. Alan Jackson could have gone on and talked about reasonable doubt some more if he had more time, but he was very limited. He did a great closing argument, I thought, but again, had he had more time, he could have connected more dots, m- planted more reasonable doubt in the minds of the jurors. But anyways, so it's a good thing, I think, that Turtleboy asked this question because it wasn't really discussed. All right, so the juror says we extensively discussed reasonable doubt during deliberations. We kept reading the charges. It was easy for the first and third charge. Whenever we read it, we all agreed that there was reasonable doubt, so we voted not guilty. But for the second charge of manslaughter, it became gray for some. Reasonable doubt to me means it's unclear. So, based on the evidence, it wasn't very clear that there could be some instances where perhaps there was some other factor that caused the event to occur. So, for me, that was reasonable doubt. So, he didn't believe the state's theory 100%. He wasn't on board. So he had some doubts. All right, so was there pressure put on the three not guilty jurors to change their votes to guilty for the manslaughter charge? Was it tense? What were their stated reasons for refusing to change their vote from not guilty? Because remember, we heard there was some bullying in there, so let's see what the juror has to say. It was very tense, more so for the side of not guilty. They didn't want to change because they felt there was reasonable doubt. There were some individuals who were very set from the beginning and wouldn't waver no matter what evidence was presented. We realized that no matter what we did, we'd never reach a unanimous decision. Remember in his first interview, he said that there were some people that at the very beginning, they came into the deliberation room and they said, well, she's guilty and I'm not going to discuss it any further. So that is jury misconduct and should have been reported. I don't know why they didn't, but that's what should have happened. All right, so did jurors discuss how the defense only called 6 witnesses and did jurors think this made her look guilty? The juror says the prosecution had asked for almost everybody, so there was no real need for the defense to ask for additional testimony. So they didn't know who the defense had on their witness list. They had a lot of people that were very, very interesting, to say the least, and I was looking forward to hearing from a lot of them. However, the defense, I think, wisely chose to cut their defense up, to limit it. They didn't show all their cards, so if there is another trial, they have some things up their sleeves, which is a good thing. However, they might have been able to bring on a few more experts or witnesses, but I think overall, I don't think they needed to bring on a ton more because it seemed very much like they were winning this whole thing because every day the prosecution looked worse and worse. So, I don't know. It's a tough call. Being a lawyer, you never know. You never know. Is the jury going to want more? Yeah. So in this case, he's saying we were fine because the prosecution called so many gosh darn witnesses. And Turtleboy clarifies, so there were 2 people on the defense list who bit Chloe. Or I'm sorry, not the people didn't bite Chloe. Chloe bit the people. Uh, yeah. Glad I got myself on that. Anyways, so Chloe bit the 2 people, not funny. So they were there to testify, or they were on the list to presumably testify about that. There was one person who was on the other end of Michael Proctor's text messages who they didn't call. I don't know who that was. I don't know who Turtleboy is referring to. That was on the other end of Michael Proctor's text messages that wasn't called to the stand. Maybe Fanning was Lieutenant. No, Lieutenant Fanning was in charge of the or the jury. So it couldn't have been him. I don't know who it was. If anybody has a guess, let me know. I haven't looked at the witness list in a while, so I can't remember. Anyways, so there was close to 40 people on their list who they didn't call. Do you think that hurt them? So again, the juror's like, I don't know what I don't know. I don't know who they would have called, but here he says we weren't privy to who else could have been called, so we didn't think it was absolutely necessary. There were certain experts that could have benefited the defense. For example, Lexis and the triggering of an event where there may be a data recorder showing when there was excessive acceleration or some sort of movement that was very specific, therefore causing the car to track the date and time. This is important because the data that was provided and discussed at trial, I believe it might have been potentially modified, changed. Um, it wasn't showing date and time. So we don't know for sure the key cycles when they happened, but we can conclude that the last 4 or 5 key cycles, it was in the state police possession. So those key cycles were theirs. And he used the wrong, Trooper Paul used the wrong key cycle to say that Karen accelerated too fast or whatever at that moment. So I mean, it's just, it is what it is. He did not use he used a key cycle where it would have been in the state police possession. So to do his testing. So it was, uh, it's just, he's problematic on a lot of reasons. All right, so that would have been beneficial for an expert from that group, such as the manufacturer themselves. I think the tech stream people, the tech stream data people should be there, not Lexus, but I don't know who makes the tech stream data. I think they said, I think I heard Toyota, but I'm not sure. All right, so they could talk about the data that was being recorded. That's what they want, is an expert who can talk about the data. They said at one point that there were 23 events on the data recorder for Karen's car, and one of those was the excessive speed, backing up, and then the sudden jerking movement or change of an angle as a direct result of a strike. That was told to us by Trooper Paul, sorry, and we wanted someone who was more experienced and had more experience and more knowledge of physics and engineering. Well, we had people that knew physics and engineering, but you guys discounted them because your engineer on the jury thought that they were paid for by either insurance or Turtleboy. So we did have people who knew physics and stuff. They just were discounted by the jury for some reason. I don't know why. Um, and yeah, we had experts in this. Not necessarily in the text stream data, which is a really good point. So either a Lexus or text stream data representative who can really speak to the data that's being recorded, and tell us what these key cycles are and why there were only um, 23 events on the data recorder since she's owned it. So yeah, all that key cycle stuff was confusing. Um, which is probably why we didn't have somebody there to, I don't know. I don't know why. It was so confusing, but Trooper Paul explained it. That's why. Turtle Boy says, so you guys were not convinced by Trooper Paul. He says a lot of us were not convinced by him. He didn't give us any equations. He didn't seem like he could answer many questions about physics. That's for sure. Well, he was the primary witness for the Commonwealth to prove that John was hit by Karen's car. If he didn't come across well to the jury, then how could anyone vote to convict her? What was their argument? The individuals who believed in not guilty felt that we couldn't correlate John's injuries to the injuries of a motor vehicle strike. It wasn't clear, based on what we saw, that the vehicle strike caused his injuries. The injuries he sustained and the injuries to the vehicle were not consistent with the pedestrian strike. Yes, clearly, this guy gets it. The not guilty voters got it. So this conversation must have occurred where not guilty voters like you said that the injuries were not consistent with a motor vehicle collision, and then the guilty voters must have said, yes, they are. So what was their argument for that? I mean, he asks great questions to get to some interesting answers here. The juror says they were basing it on data. The data was showing that based on the data, the vehicle backed up and changed direction. Again, we don't know that this was even the key cycle that is correct. So, and that's even true. And it doesn't tell us that she was going in reverse 24 miles an hour. I don't think it ever like verified that she was in reverse. It just said that the car was going in 24 miles an hour and they just assumed that was her going in reverse. So none of it adds up or makes sense. Anyways, so, and there were some injuries on John O'Keefe, and then he died. So, because he lost his life due to the injuries, which we still don't know how he got, but because the car changed direction and backed up and went 24 miles an hour at some point in time, um, Karen did it. I don't know how we're getting from A to B here without, making a lot of inferences. All right, so based on the data, they didn't even consider this other scenario where he went in the house. So the jury didn't even consider that he went into the house. Yep, you got that right. You heard that right. I mean, come on. There were two scenarios being presented. One was the prosecution scenario that Karen hit him with a car. Two was the defense's scenario that Karen's being framed and that John went in the house. John lost his life due to the people in that house. I mean, those are the two narratives. So, how did you not even consider that scenario? I This is infuriating to read. It is this these people, the guilty voters, were willing to just throw someone else's freedom and life away for 15 plus years in prison, which is what Karen could get if she was charged or found guilty on the manslaughter charge. Probably would have been life if she got second degree homicide, but um, she would have the possibility to be paroled likely within like 15 years if she um, was found guilty of manslaughter. So do people not put themselves in other people's shoes? Because that's how I try to live my life. I don't know about others, but I'm not willing to throw someone's life away based on what I saw in that trial. At least not Karen's. Maybe some of the McAlberts, but not Karen's. So it seemed like Karen backed up at a high rate of speed. Again, we don't know that. The data that was presented at trial does not say that she was going in reverse at 24 miles an hour. It just says at some point she went 24 miles an hour. The only other thing we could think of was it was snowy and icy. Could the vehicle be stuck on something, gun it, and maybe it interpreted this very high revolutions per minute as 24 miles an hour? That's also something that had been discussed that maybe because it was icy, slippery, that a tire might, spin a little and register the car as going 24 miles an hour, but it wasn't. So that might be a possibility also. So this is to me where there's reasonable doubt about the data. Very good. This juror gets it that there's other possibilities for that argument. All right, so you're saying that for the guilty voters, the Lexus text stream data was really solid evidence, and you believe that a good witness for the defense to counter that would have been some sort of Lexus expert who can explain what the data means and if it really meant that she went 24 miles in reverse. Correct. I mean, Turtleboy asks great questions. He could have been a lawyer, I think, with his um, questions and wishing to argue, but whatever. So the juror says correct. And that's the other thing. How is it in the entire lifetime of the car that she only had 23 triggering events? It's another good question. Can revving the engine create a triggering event? Yeah, what exactly is a triggering event? It would have been nice to know. So Turtleboy asks, can you please clarify what you meant when you said that one of the jurors spoke to a family member who alerted them of my presence in the courtroom? And this, I think, goes to misconduct here because they recognized Turtleboy. This juror did, I think. And yeah, and then they thought that the text stream was paid for by him. He admitted in the first interview that him and some of the other jurors were talking about Turtleboy. So Turtleboy wanted some clarification on that. So the juror says that was something we discovered in the middle of the trial that he got kicked out of the courtroom. One of the jurors said they recognized your face in the courtroom, and from there, other jurors talked about it, and family members were telling them information. Oh, so this wasn't when he got kicked out. Sorry, this is just because he was in the room reporting and sitting in the sitting in the media gallery. One of the jurors' family members said that they were pointing out that one of the jurors was wearing a bow tie. And that wasn't my family members, but one of the other jurors' family members knew that. So the family members, Aiden said something about a bow tie on a juror, and somebody who was a family member of that juror said something to that juror, and word got around or something, said something to another juror. Somebody said something, and it got around. So they're discussing the case pretty much. I mean, they're not discussing specific details about the case, but still, what are they talking about Turtleboy for? Because he is being charged wrongly for witness intimidation in this case. So why are they talking about Turtleboy and what else did they discuss there? It's very odd that it was brought up. So he said during deliberations, we discussed it a little bit more. So what does that mean? They discussed more about either the publicity that they were getting or more about Turtleboy and his antics that, make him so controversial, and who knows what they were talking about. That's why I think they need to be called back in for that reason. If not only just to acquit Karen of charges 1 and 3, they should also be asked about this, talking about Turtleboy and talking to family members about the case. So Turtleboy says you were told not to talk about this case when you went home, but it sounds like this juror talked to a family member at home who was watching my show or reading my tweets. That seems to be a violation of the judge's orders, does it not? And this juror says the judge ordered us not to discuss the case. So that is pretty much confirming, yes, we're not supposed to discuss the case, so that would have been probably a violation. But he's not coming out and saying it's a violation. He says she knew and we knew it was everywhere. So tweets and blogs and videos about this case everywhere. One of the things we were asked to do was not watch news coverage. I continued to work throughout the trial, and whenever my coworkers began talking about it, I left the room. So remember, he's an EMT. Sometimes don't they get like 24-hour shifts and things like that? Like he had to have been working the craziest hours. Because remember, the trial, sometimes it wasn't on Tuesdays and Thursdays, it's only half a day, and sometimes they would just skip a day altogether. So I don't know what was going on with the schedule. It was really wacky. And then on top of that, he's trying to work throughout that, which is just wild. And as an EMT, you get put on for a long shift. And then after doing jury duty and a long shift, that's got to be pretty exhausting. But, anyways. This jerk continues. I continued to work throughout the trial, and whenever my coworkers began talking about it, I left the room. So this juror saying basically, yes, we were told not to talk about it, and I didn't do anything wrong. I didn't talk about it, and if any heard anybody talk about it, I left the room. But I can't speak to what this other juror did and what family members they talked to about the case. So he's kind of like distancing himself, which I would. That was a good answer, anyways. All right. So, did your coworkers know you were in the jury? They eventually found out. They added it up because I was gone for long periods of time, and they knew not to talk about it in front of me. So somebody must have said, "Don't talk about the Karen Reed case in front of so and so." So you live in Norfolk County, right? I mean, this trial is Norfolk County. Canton is in Norfolk County. This juror says, actually moved to Middlesex County. So I still had my old address on my license. That's how I ended up on the jury. So people that live in Norfolk County are supposed to serve jury duty on at the Norfolk County. People at Middlesex are supposed to serve jury duty at Middlesex County. So what went wrong here? I mean, I'm sure in the voir dire process they must have asked if you live in Middlesex or if you live in Norfolk County, right? And if they didn't, I mean, I wouldn't say it's calls for like a new trial or a mistrial or anything like that, but I would definitely have this investigated, looked into. I'm not saying that this juror did anything wrong, but why was this person allowed on the jury? And why weren't they ixnayed on the during the voir dire process? I don't know. It doesn't sit right with me that someone from another county is sitting on this uh jury. Just wonder, it just makes you wonder, like, why? There's so many little things in this case that like add up to so many big things. All right, so next, Turtle Boy says, what were the top three reasons that guilty voters insisted she was guilty? He, th- the juror says, one, alcohol consumption. This is the biggie, and that I think people have a bias against drunk drivers, and they don't like it. And again, most people shouldn't have been on the jury if they had such strong convictions about being against drunk driving. Then you shouldn't be on this jury. But they might not have been honest in the voir dire process. So this might be something to look into too, because they were really hung up on the alcohol consumption. They said that showing the drinks she purchased. So remember, Yuri was like, "Oh, she's buying drinks. She's doing a shot there. She's drinking there. She's pouring that." He was like making stuff up as he was going along. He wasn't supposed to be narrating, first of all. And sometimes she was buying drinks. We don't know what her drinks were, and she could have been drinking tonic out of her glass and then just adding who knows what. So you can't sit there and say, she did 9 drinks when there's no evidence of that. And the receipts, there was no evidence of 9 drinks. And she could have purchased drinks for people. So she was very generous. She is a very generous person and would be very generous with her money. So this means nothing to me, but it meant a lot to the jury. And the blood alcohol level in the morning, but they took it in the morning, not immediately after the supposed incident that she did this, where she hit him, supposedly. She didn't, but that's what they say. All right, so number 2 was the text stream data. We went over that already. They really tried to hone in on the alcohol consumption, the text stream data, and the fact that they were there at the same time, which we'll get into that in a second. So hold your thoughts. In my opinion, that didn't prove that she was drunk that night. She could have drank when she got home. They never tested her blood alcohol level until the next day. Correct. That is correct. So, plus, she was sanctioned against her will. They took her blood alcohol without consent, and um, it's against the law to do that. I mean, the way that her blood was taken was not following procedure and protocol or the law, because she would need to sign and waiver and say, I agree to this toxicology for testing type of thing, and she never did that. So they should have never even used it. And to top it off, the extrapolation that they used to retrograde back to, midnight, when it's like 8 in the morning now and they're taking her blood, they think, that it was, there was like this huge wide range of where her blood alcohol level could have been as their guesstimate. So none of that makes sense to me. Um, Leading to reasonable doubt and the fact that she's not guilty. All right, so what do you mean they were there at the same time? So that was his third answer here. They were there at the same time. He says the mere fact that they placed them there at that time and everyone else in the household claims they never saw him. So those pieces of information made these jurors believe that she was guilty because they were there at the same time, which makes no sense. Which, if these are your reasons, you're a plant or you're easily manipulated by plants. If those were your reasons to vote guilty. All right. So next, did jurors find it all suspicious that not one of the people who left the house reported seeing John's body on the front lawn? Matt McCabe said he saw tire tracks in the snow, but missed John's body, which was closer than the street. Was that brought up? The juror says one of the things we deliberated on was whether or not There was enough lighting in the area. There was no street lights in the area to illuminate it. Yes, but cars have headlights which would illuminate it. So whether or not there's a street light there really doesn't matter. Plus, you got snow on the ground, making the world brighter. Everything reflects off of that white snow, and the world is just a little bit brighter. So don't, I don't- the not being able to see or the fact that it might have been dark, I don't buy that at all. Plus, aren't they by like a flagpole and a light? I don't know. It doesn't make sense. But whatever. All right. So could it have been missed if you're not looking for a body and it started to snow? I don't think so, because headlights, man. We've seen somebody post a video. It might have even been microdots, like somebody backing out of a car. You're seeing it like you're in the car driving and you're backing out, and then you turn and go into the street. And of course, you would see a body because your headlights light that person up. So some people weren't sure, but they were sure that she was intoxicated, and there was text stream data showing 24 miles an hour, and her and John were there at the same time, and he's no longer alive. So therefore, she's guilty. Thank you, guilty voters, for showing the world how easy it is to put an innocent person away in prison. Or at least try to. So let's talk about them both being there at the same time. Heather Mason, Ryan Nagel, and Ricky Dentano all testified that Karen was alone inside her car and that John was outside or wasn't outside the car or inside the car with her. So he wasn't there. He wasn't on the lawn. He wasn't standing outside the car. He wasn't in the car with Karen. So where did the guilty jurors think John was? He says, we did discuss that, but at the end of the day, the individuals who believed that she was guilty remain guilty. This is what I'm talking about, more jury misconduct that they just won't, or like they won't even argue or, listen to other sides, sticking their foot down or putting their foot down and like just being difficult to even talk to during deliberations. It's my opinion, is what was going on in there. All right, so yeah, I get that, but I assume a not guilty voter must have pointed out that none of these people saw John inside or outside the car. What was the response to that from the guilty voters? There was a lot more strong personalities for guilty, and essentially that made it very difficult for an argument from the opposite side. That's what I'm saying. So there were strong personalities really gunning for a guilty on manslaughter, which again makes me think that there's plants on the jury. And they were easily able, like, all it takes is one or two. And then you're easily able to manipulate and argue your way with the rest of them to get your guilty vote. Crazy. And essentially, that made it very difficult for an argument from the opposite side. So, again, they're not even allowing for discourse on like the very important things like did he go inside? Was he in the house? Where was he when Heather Mason and Ryan Nagel and Ricky Dantano all drove by? Where was he? They didn't even talk about this? Seriously. So Turtleboy asks, it's my understanding that the four not guilty voters at the end were you, the skinny guy closest to the witnesses, the young nurse, and the woman next to her with the long dark hair and glasses. Were these people quiet? They clearly believed Karen Reed was not guilty, but did they try to convince others that she was not guilty? We did go around the room to speak our piece, explaining why we felt the way we did, but as we went around the room, we realized we were at an impasse because several people simply wouldn't waver no matter how much evidence was presented showing reasonable doubt. Several people simply wouldn't waver no matter how much evidence was presented showing reasonable doubt. Jury tampering, jury misconduct. 9-3 is a pretty close to getting a verdict, right? Okay? I mean, it is. Like, those three steadfast people, thank God for them. Those three people that would not say guilty on manslaughter. Good job, guys. You guys, Karen owes you. All right, so did the guilty voters at that point put pressure on the three remaining not guilty voters to say the O'Keefe family needs closure? What can we do to convince you guys that she's guilty? The juror says there was. So there was pressure to get justice for John O'Keefe and his family, but not thinking that justice for John O'Keefe could mean not putting an innocent person away. Anyways, he says there was, which was why it went from 6-6 to 9-3. It was because there was a little bit of, I don't want to say coercion, but that they stressed she was under the influence of alcohol and that she should be guilty of some sort of crime related to that. I'm going to read that again because this is what's going on in our deliberation rooms, and it's very, very scary. We are in a society where we want to get our lynch mob together and our pitchforks and our shovels and pitchforks, and we're going to go after that son of a bitch who did this crime because the law enforcement says he did it, even though we haven't even looked at any evidence. We are this lynch mob of a society, and it doesn't stop in a jury room. So this juror says, I don't want to say coercion, but that they stressed she was under the influence of alcohol and that she should be guilty of some sort of crime related to that. Well, there was no crime just related to drinking and driving. Her crime was you deliberately took John's life or you accidentally took John's life. Those were the two big options there. And then the last charge was leaving the scene. So it was either intentional or unintentional that she did it, according to the state. You can't have it both ways. And I don't think that we should have these compromise verdicts. I don't think you should be able to go for both and have a bite of the apple of both because you have jurors who are like, I just want to finish deliberating, so let's just get this compromise over with and go for the manslaughter, which is still like 20 years for somebody in prison. 15 or more years usually is, and you might not even get parole. So this, we can't be so willing to just throw people in prison, and that's all I'm saying. All right, just trying to make that point. All right, so and that's why we settled on involuntary manslaughter. Again, they settled. They wanted to get her on some sort of crime. A lot of individuals changed their vote because they were convinced that she was operating the vehicle while intoxicated and likely took his life by accident. But again, still you have to look at the evidence of the ARCA guys and the damage to the car and John's injuries. They just don't mix. So, what did you think of the inverted video? Did you feel intentionally deceived? The juror says it was confusing because you would have to tape the video to videotape the tape or the video. I don't know what he's saying. Like you'd have to videotape the video and then flip it somehow. I don't know what he's talking about. So that's what we came up with. We did discuss it, but by that point, it didn't matter because the guilty voters were convinced that no planted tail light. There was no planted tail light, they say. So that's a good cue for the defense to make sure that they drive that timeline home that CERT wasn't able to start their search for the taillight pieces until 5:45. But I'm trying to, I think I've got my times right, but the car arrived at the Sally Port around 5:15. And then, so that's, there's plenty of time for them to have shattered or tried to break her taillight and then bring some pieces over there before CERT even starts. And then CERT only searched for a half an hour, and then they were done. By 6:15 they were done. They started at 5:45, and by 6:15 they were done. Brian Tully told them exactly where to search. So these are the key things that the defense needs to drive home about the planted taillight. It was absolutely planted taillight. All right, so this juror continues. So it didn't really matter what happened in that garbage. I think he means garage, in the garage, the Sally Port, or if the video was inverted. All right, so Turtleboy asks, why did people believe it wasn't planted? He says the defense created the idea that the tail light was broken when she collided with John's car. Backing up, guilty voters believed that this didn't make any sense because there would be broken tail light in John's driveway. And I want to stop here because um, I was listening to the Las Vegas cops. They're really good. They've been going over testimony of different people and law enforcement because they were law enforcement and they're in Vegas. And they have some really good perspective on like what things should have been done in this case and what things went really wrong in the investigation. And I was re-listening to Paul Gallagher's testimony, and he said he mistakenly went to One Meadows Ave so he went to John's house before he even showed up at 34 Fairview Road. He said he mistakenly thought that that's where he was supposed to be going. So my question is, where was the ring camera from this? And did he possibly go and maybe look for taillight pieces? I don't know. I don't know if at that point they were even spinning the taillight piece story yet, but um, it makes you wonder. Maybe he went there and looked to see if there were taillight pieces in the driveway and brought them back to the scene. I don't know. I'm not saying he did, but it just makes you wonder why he went to One Meadows Ave first, John's house, before he went to 34 Fairview Road, which, by the way, he was told it was 32 Fairview Road. But anyways, so yeah, that could be why there was no tail light in John's driveway. Somebody may have gone to get it. We all felt that it wasn't as credible. We believed that the individual who put the car on the flatbed in Dighton, the tow truck driver, would have been a valuable witness to the defense. I agree. And I wonder if they ever took a photo of the truck or of her SUV before they put it on the tow truck. They could talk about the condition of the tail light and would be a very credible witness. I agree. And we all talked about this too on content creators talked about that he would be a good witness if they were able to get that tow truck driver, but I don't know if they were ever able to track him down. You know what? I'm gonna pause here and be right back because my dog needs to go out. So hold on 1 second. And we're back. Sorry about that. All right, so let's continue on. Turtleboy asks, I do wonder why they didn't call the tow truck driver, so the person who drove or towed Karen's car from her parents' house to the Sallyport. But Turtleboy changes the subject. He says, let's talk about the Dighton police officer, Nicholas Barros, who testified that the taillight was cracked, not destroyed. Remember, he said it twice on the stand. It was cracked, not destroyed. Did jurors pick up on that? Do you think the defense should have cross-examined him? Juror says those individuals who felt she was guilty didn't look at stuff like that because they were stuck on the other things like the text stream data and the alcohol consumption. So they were really obsessed with that. But I agree. It would have been beneficial to the defense to cross-examine Barros and show him a picture of the tail light that state police entered into evidence and ask him if the tail light looked like that when he saw it in Dighton. So the destroyed photo where it's like almost completely missing, um that one I would yeah, I'm sure the defense didn't want to ask a question they didn't know the answer to, but I have a feeling if they had shown them the pictures of Karen's car in state police custody, um, they would have, he would have said, no, it didn't look like that. That's just my feeling. All right, so as a first responder, what would you have done if you came across the scene and heard Karen Reed say, I hit him? Would you inform police on the spot so that she doesn't leave? So remember, this guy's an EMT, so Turtleboy's asking him, from your personal experience, what would you do? He says the scene would have been chaotic. Unless she was that expressive, I would have dismissed what she said and focused on patient care. So unless she like specifically said, I hit him and this is why this happened, then he probably wouldn't have been focusing on that. He says, I would have hoped that law enforcement picked up on it, unless, of course, at the hospital I wanted to give reports to the nurses and doctors that this was a trauma. So that is something that first responders are able to do when they arrive on the scene with a patient. They can say, I picked this guy up. He was unconscious on the lawn. His girlfriend said that she hit him. With what? I don't know, but that's what I heard. That's that most people would relay that message to medical professionals to make sure that, he's taken care of correctly. So anyone who did hear that and didn't tell medical personnel, that's on them because I don't think they actually heard that. But, anyways, firefighters Flamati and Nuttall both testified that they did not inform doctors at Good Samaritan that Karen Reed said, I hit him, I hit him, I hit him. As a matter of fact, they weren't even interviewed by police until February 7th. So, over a week later. So I understand that in the heat of the moment, you wouldn't tell police this, but wouldn't you tell police about it after things calmed down and the investigation began? These firefighters admittedly didn't do that. And this EMT slash juror says, I would if I remembered it. So he would absolutely tell police, law enforcement, I heard Karen say I hit him if he had, in fact, heard that on the scene. So it makes you wonder why that was never reported until grand jury testimony to get her indicted. All right, so Turtleboy asks, did you think it was strange that these firefighters didn't offer any of this to police until the time blah, blah, blah. Start over. Did you think it was strange that these firefighters didn't offer any of this to police until the police came to them 10 days later? And if so, during deliberations, did you use your experience as an EMT to say that this was unusual for first responders not to say something? He tells us, so in deliberations, we didn't really look at that. We accepted their testimony and didn't really look at that as evidence. You're supposed to, like all testimony is evidence, you're supposed to weigh the evidence. You're supposed to decide if the people giving testimony are telling the truth or not. That's part of their requirements as a juror. So he said, we accepted their testimony and didn't really look at that as evidence about whether or not she was guilty. I hit him was not testimony that we were considered to determine guilt or lack thereof. What we looked at a lot was the testimony of the medical examiner who put what the cause of death was, which was a fracture of the base of the skull. And the point of impact was from behind, and there's arm injuries and hypothermia. So, could that be related to the backing up of a car? And the guilty voters felt that the car must have impacted him somehow. Okay, how? You're just defying physics and stuff. So, the not guilty voters felt those injuries were not normal injuries to a pedestrian strike. True, they're not. And the damage to the car didn't correlate to hitting someone as large as John. Remember, he was over 6 feet tall and he was over 200 pounds. So he was a big guy. In your opinion, but in your opinion, but in the opinions of the guilty voters, they were consistent, right? So in your opinion, The opinions of the guilty voters were consistent. He says they just looked at the text stream data and the fact that John was injured and died, and that Karen was driving a car under the influence of alcohol. So they didn't use any reasoning or logic. Okay, great. You said the engineer pointed out his background in engineering to discredit the ARCA expert. Did you mention that you were an EMT and did other jurors ask your opinion based off of your expertise? He says they did. They asked the experts in the group during deliberations about their opinions. Anyone who was medical, they asked what our opinions are. So that's good at least. And then one of the experts was a nurse. I think he means one of the jurors was a nurse who was a not guilty verdict. So I guess they didn't listen to her or you. Were the guys quiet and were you guys, the not guilty voters, were you quiet and not persuasive? He says we had reasonable doubt, but again, the others looked at the text stream data and ignored the experts. One of the instructions from the judge was not to ignore the data and use our life experiences. So they looked at it as Karen was drunk, she backed up, and there were injuries that led to John's loss of life. So for them, in their minds, there was guilt beyond a reasonable doubt. I don't even know what to say. They ignored so much information and just stuck to a narrative like the McAlberts stick to their narrative that Colin wasn't in the house and John never entered the house. All those narratives. I think there's a plant. All right, so did the jurors find it odd that Michael Proctor found large pieces of taillight on February 18th that were larger than pieces of taillight that were found previously? Those who believe the taillight was there and not planted, their argument was that when this occurred, there was not enough snowfall. So it was in different layers of the snow and likely the lower level. So that's why, as the snow melted, they continued to find more taillight. They never pointed out where each piece was found. So that's a good point, too, is that there was never a map or anything about where each piece of taillight was found, to reconstruct how there wasn't pictures taken of anything. But what was I going to say? This whole theory about the taillights, if they weren't planted, they must have been in a layer of snow that was much lower. I want to make you guys understand that when when John was found in 6 in the morning, there wasn't that much snow on the ground, maybe a couple inches. And it was still like the storm was just starting to pick up at that point in time. So by the time CERT got there, there was more snow. So why did Canton police not find any taillight pieces? This is so concerning. Canton police didn't find any taillight pieces when there was very few inches of snow, but yet the CERT team arrives at almost 12 hours later after the storm has passed, and they finally get authorization to go because now Proctor's got Karen's car in his possession so he can get the taillight pieces. So they call up CERT and say, hey, you're ready to go once they planted them. I mean, this makes so much sense to anyone that uses their brain. I just don't understand. But okay. Um, yeah, the layers of snow. We saw in trial, we saw Sergeant, was it Gallagher? It was Lieutenant Gallagher playing the video of him with the or the leaf blower blowing the snow around. You could see that there weren't taillight pieces. They never found taillight pieces. And you could also see that the snow wasn't that deep. That Canton police are incompetent. Don't get me wrong, but I think they could have found red pieces of taillight in that little bit of snow. that we saw on the video. Maybe with her leaf blower. Ay, ay, ay. All right, so they actually did testify where each piece was found. Do you think this confusion was a byproduct of not being able to review transcripts of testimony? He says, I think eventually they did, but it wasn't as organized as you would expect they would have. They should have shown us a nice map, and it seemed like the taillight was all in one area, which is consistent if they actually searched the small area. So some jurors looked at it as taillight could have been in different spots in the yard, and we looked at the idea of whether or not the leaf blower would have moved taillight to different spots in the yard. Well, you would have seen them though. You would have seen it move because they were only blowing off the top little layer of all their trace evidence that they had on the scene. They blew it away. The majority believed that the taillight was already there and they continued to find it as snow continued to melt. That is ridiculous because they dug through all the snow. So the pieces that were later found, we don't know where they were. There were like 4 or 5 undocumented searches that Trooper Proctor did at that house and entered more evidence, more pieces of taillight. So was he even there? Did he even go to 34 Fairview Road, or did he just go, oh, here's some more taillight, put it in an envelope and go, oh, yeah, find it on the front lawn. Here you go. That's what I think he did for the coming weeks after, honestly. All right, so Turtleboy asks, sounds like it's safe to say that the taillight evidence factored much more into the minds of the guilty voters than the I hit him, I hit him, I hit him. He says, correct. So you mentioned that you or the engineer believed at one time that John fell backwards because he perceived a threat. What did you mean by that? So he starts off by saying one of the theories that we deliberated on was dot, 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 dot. Well, if you're not deliberating on the two theories presented at trial, either she hit him or she's being framed and he was hurt inside that house. If you're not choosing one of those, that's reasonable doubt. Well, if you're not choosing the state side, sorry. If you're not choosing the state side, that's reasonable doubt. You have to believe what the state's theory is telling you. And so many people don't get that. If the state does not prove their case, that's not guilty. If they don't prove every aspect of their theory, you can say, hey, there's reasonable doubt. But anyways, so what did he mean by John fell backwards and perceived as a threat? The juror says one of the theories was deliberated on. If you see a car backing up and based on your perception you actually try to avoid it, could John have seen the car backing up at a high rate of speed and he actually ultimately fell back? And in the process of falling back, could the car have brushed him and broke the taillight? And because you're imbalanced and intoxicated, you fall back. Right before he fell straight back, could there have been impact on the tail light area on the arm? If there was someone good in physics, like the biomechanical engineer that we heard, Dr. Rentschler and Dr. Wolf, the ARCA experts, maybe those guys are good at physics. They built their own cannon to try shooting a cocktail glass at the back of a Lexus to see the damage it would do. The government spent over $500,000 on the ARCA experts. The government does not do that unless there's a reason. And that reason is investigating, I believe, the Alberts. And not just the McAlberts, but the DA, maybe even Judge Cannoni now, after seeing her behavior during this trial. Anyways, physics. Someone good in physics who could have explained that for the prosecution that would have been beneficial if there was someone good with physics that would help them understand. But no witness said that. It was based on Trooper Paul's testimony, and he said John did that pirouette everyone laughed about. So instead of that theory, we discussed if John, instead of being able to move out of the way, he fell straight back. But in the motion of him falling back, the car impacted his arm, causing scratches and abrasions, and then he ends up hitting his head on the ground, and the ground is hard enough to cause the skull fracture. This is not true. The ground would not have been hard enough to cause the injuries that he had to his head. No way. He had injuries on the front of his face too. So, and his eyes were swollen. His occipital bone was, I think, swollen, fractured. I don't know. But in bad shape. Could a video recreation with a crash dummy or a computer simulated program have been beneficial? He says, yes, I think it could have been beneficial for both sides. If the prosecution could show us a video showing us how how John was hit, or if the defense could refute that, it would have helped either side. And also a witness who has some sort of background in physics or engineering. I think Trooper Paul was a new guy who they put on the case, and they didn't realize it was going to be such a big case, and he never did his research. That's pretty embarrassing. Sorry, Trooper Paul. Even if you don't know at the time, immediately you could do your research. So he was not prepared on the stand, is what he's saying. All right, so did the jurors find the McAlberts to be dishonest? Colin Albert said he cut his knuckles slipping on ice and had never been in a fight. Brian Albert said that he but answered the phone while having relations with his wife and but dialing simultaneously. Brian Higgins. Jennifer McCabe said that 20 deleted phone calls were never actually deleted from her phone, and she also had a bunch of butt dials. Katie McLaughlin said that she barely knew Caitlin Albert. That's the firefighter McLaughlin who is good friends slash sorority sisters, I think, with Caitlin Albert. I don't know. They go back a ways. If jurors thought they were lying, how then could you trust or believe anything that they say? So all those people that are just pointed out that had some really fishy, interesting things that they said on the stand. The juror says one of the things that we looked at was whether or not each witness was credible, but ultimately guilty voters thought that the testimony of them, meaning the McAlberts, wasn't really important. Like hell it is, isn't? Like hell it isn't. It's absolutely important because they're potential suspects in a case that they were never investigated because of their relations to the cops. We looked more at the text stream data. We looked at the evidence that she was served alcohol and operated a vehicle, like they all did. That she was with John O'Keefe at one point outside the house, and that ultimately John lost his life during that time frame. I get what you're saying that about credibility of people inside the house. What about the credibility of the people inside the house? Turtleboy says right, because if he didn't go in the house, then Karen Reed did it. And they're all saying Karen didn't go, I think it means Karen didn't go into the house, but if they lied about other things, why wouldn't they lie about John going in the house, since it would protect them from being suspects? The juror says, unfortunately, the other pieces of evidence overruled everything else for the guilty voters. For others, they couldn't find them credible, and it was reasonable doubt. I mean, it just doesn't make any sense that they just keep going to, well, she was drunk and he lost his life, so she must have done it. You're completely ignoring so much contradictory evidence. Anyway, so Turtleboy says, is it safe to say that they did feel that Colin Albert was lying about his knuckles, but it didn't matter because they thought the text stream data was more important? He says, honestly, some of the guilty voters didn't think he was lying. That being said, some individuals did agree that it was very scripted and they always had an answer for everything, like, I do not recall. or show me where I said that. They always had an excuse for why something wasn't the norm. It was very strange, and that was noted by many on the jury. So others just had it in their minds that she was guilty, so it didn't matter. I just don't get how you ignore that. Did the jurors think Jen McCabe searched for how long to die in cold at 2:27 a.m.? If they couldn't be sure either way, wasn't that reasonable doubt for Karen Reed? He says they dismissed that as low-hanging fruit. They said it wasn't that important to look at. They viewed it as a distraction and fluff and that we should be looking more at that said that we should be looking more at what was at was that she was drunk. Language, the grammar, something that she was drunk, drove a car, backed up the car, and she had damage to the back of her car. John was injured and he died. So they're not even looking at relevant evidence. It just doesn't make any sense to me. Turtleboy asks, but I think we all agree that if the Google search happened at 2:27 a.m., then it is a conspiracy. So would you say that not much time was put into discussing the Google search? He said, yeah, we didn't really spend much time discussing the Google search. Some said it was fluff, and that was designed to convince us that the defense was playing this reasonable doubt thing by introducing all these weird things. It's not fluff, man. Like the Google search and the dog bites. Yeah, okay, it's fluff. Actual evidence in the case, just fluff. The focus was, did she do it? And ultimately, the guilty voters felt she was drunk, accidentally hit him, and that's what took his life. Wow. I mean, such narrow-mindedness and not being able to like open your mind and be flexible to other things. So, did jurors find it odd that no conversations with witnesses were recorded, that some witnesses were not spoken to for more than a year, like Colin Albert, Caitlin Albert, Sarah Levinson, and Tristan Morris, and that police never considered any other potential suspects besides Karen Reed? He says some found it odd and some didn't. If someone loses their life on a front lawn, and I said I didn't know how he ended up there, I would think that everyone, including the neighbors, would be interviewed. And none of that was gleaned upon the jury. I don't know what that means. None of the jury really talked about that. So we don't know if that happened or didn't happen. We just know that this was the pieces of the case and that was presented to us. We don't know if they did it or didn't do it. You can see on either front someone saying that should have happened and another person saying that it probably did happen, videotaped interviews, and they didn't give us that information because the witnesses didn't see anything. That was a whole lot of rambling. Basically, why weren't neighbors and other people interviewed? Why weren't the Alberts looked at? Question from Turtleboy is, were jurors aware that both houses across the street from 34 Fairview Road had ring camera videos that would have shown the alleged car crash? He says, we weren't provided that data and no one testified that there was ring video, so we wouldn't know anything about that. He says, how did jurors feel about closing arguments? Alan Jackson gave a very spirited speech, and looking at the jurors' faces, they seemed moved by it, but I guess not. What did jurors think of closing arguments? He says some jurors were happy that the closing arguments were kept to an hour because we really just wanted to deliberate. We talked about at the end how one was more powerful than the other. Jackson's closing argument was stronger and it went through everything, but it didn't change the minds of the jurors. We looked at the instructions to see if she was guilty of the three charges. We looked at the judge's instructions to see if she was guilty of the three charges. So he repeated himself there. All right. So were the text messages with Higgins discussed at all in deliberation, and did this impact the jurors' view of Karen? Did they judge her because of that? He says, it was quickly looked at for a minute or two and then we moved on. No one thought Karen took his life on purpose, so it didn't really matter. I mean, Are you listening, Commonwealth? It didn't matter. He brought up so much drama. The Aruba sisters, the Higgins text. Higgins embarrassed himself in front of everybody for no reason. Yeah. Did we need all that? Turtleboy says, did you decide on the homicide charge on the first day? He says, I think we reached a full consensus of not guilty on the second day. Turtleboy asks, was there ever any formal votes on the homicide charge to see where the group stood? He said, we did that multiple times and it was consistent for charges 1 and 3. Eventually, we stopped voting on the homicide charge because it was 12-0 every time. We spent the last 4 days entirely deliberating on manslaughter. So, bam, Judge Canoni in your face. They stopped deliberating on counts 1 and 3. He says it right there. And they spent the rest of their time deliberating on the manslaughter charge, which they were hung up on mostly because of her instructions and because there was somebody on there that was like, we got to get her guilty. Did the jurors discuss the verdict forms or want clarification, or did they understand it fully? Was the jury divided on charge 2 because they didn't understand it? He says some individuals were confused about it. One person read the whole thing out loud and made sure it was clear that what the charge was and what we were going to vote for. So it was definitely discussed and it was clear in individuals' minds what we were actually voting. And that's what caused us to send the vote that we couldn't reach a consensus. For some individuals, it was very clear that they were not going to move from their stance. Were jurors aware that if there were multiple possibilities with evidence, i.e., the crash daddies saying, that's the ARCA guys, the crash daddies, saying a vehicle strike was impossible versus Trooper Paul's theory that shows reasonable doubt and so it must favor the defendant? Did they understand that in the jury instructions? He says the piece that was the reason that some individuals felt one way versus the other was that they didn't have enough evidence to clearly state there was reasonable doubt. What? There's so much reasonable doubt, and like this is a case of reasonable doubt. For those who believed there was reasonable doubt, they thought there were no other possibilities or so many other possibilities for how John died. Sorry. I think the justice system worked in this case because it wasn't one person determining she was guilty. It was 12 people who ultimately couldn't agree if she was guilty on the manslaughter or not. So I think what he's trying to say is, even though it came out as a hung jury, I think he's saying that the jury system worked in this case because there were people against her that wanted to convict her, but the not guilty voters held true, and for that reason, she wasn't convicted. She's still breathing free air at this moment. She's still under a lot of pressure and stress and has these charges pending, but she's still walking free at this moment because she's out on bond, obviously. All right, so let's talk about public opinion. You couldn't pay attention to this sort of stuff, but Court TV and others put up polls asking viewers if they thought Karen Reed was guilty, and it was like 90-10 in favor of not guilty. So it's odd that the jury would have a sample that was so statistically at odds with the rest of the population. Have you had a chance to glean public opinion on this, and has it changed your opinion on the case? He says, I still feel there was reasonable doubt based on what the medical examiner thought was the cause of death. The injuries are not consistent with a motor vehicle collision, and the damage to the car was not consistent with causing significant impact to cause a skull fracture. That was enough reasonable doubt for me, but the others it wasn't so clear. He says, would you agree that the medical examiner's testimony was inconclusive, which allowed the jurors to come up with their own conclusion? He says, a lot of individuals who testified left us thinking it could go in either direction. That's interesting. Other than the data showing because I feel like everyone that testified showed that the prosecution had no case. Other than the data showing she backed up and under the influence of alcohol at the time when she was with John and he sustained his injuries. I said the data wasn't consistent with being struck by a vehicle, but other people ignored that data and looked at the text stream and other evidence we keep going back on. So they just keep going back to that text stream, and she was drinking. I don't understand. I don't fully understand the text stream. I know Trooper Paul didn't, nor did he explain it well. So how could this jury be so sure that the text stream was correct, coming from an unreliable Trooper Paul? I just don't get how they can be so sure. All right, so Turtleboy asks, have you reached out to other jurors and suggested coming forward and declaring that the vote on homicide was 12-0 for not guilty? He says conversations with other jurors are mainly about the media. People are worried that the media will be camped out in our backyards. He says, so you haven't talked about the facts of the case since then. He says, not me. I don't know if the other jurors have. There's two group chats, one with the alternates. We gave them some details about the deliberations since they weren't there. We created the text message group to mostly talk about if people were being harassed by the media. I have not approached them to let them know I am talking to you, but they've probably figured it out. Yeah. It's funny too that you just know that the DA's office, Michael Morrissey and Adam Lally, are like just waiting for these juror interviews to come out so they can see what they can, they can learn from them and try to win their case in that way. So you know that they're just waiting, and it's gotta irk them so bad that they have to go to the Turtle Boy Daily News website to get their information about the jurors. I think it's hilarious. All right, so Turtle Boy asks, yeah, they probably know since I've identified you as an EMT. Are you okay with that? He says, I don't think there's anything wrong with that since I haven't named anyone by name. Plus, he's not like saying anything bad about people. I mean, it just the guilty voters, but he hasn't named any of them, so all right. All right, so the foreman filed an affidavit asking you to have his name impounded or asking, not asking you, sorry, asking to have his name impounded by Judge Canoni and specifically mentioned me as a safety threat. I don't bite, I swear. Are people afraid of me? Are they worried that I'm going to dox them? He says, I think there's a public perception that media may be a threat. There's also a perception that law enforcement and other individuals would seek revenge on the jury because we voted to acquit her on homicide. Those are the people who you should be afraid of, law enforcement and the McAlberts, who are seeking revenge on the jury. And I guarantee if anyone tries to seek revenge on them, it won't turn out well for that person or those individuals. And since there's so much witness intimidation going on right now, I'm just saying, if that does happen, that people try to tamper with the jury, uh, that's going to really, or get revenge on the jury, that's going to really not go over well, I don't think. All right, so since we last spoke, have you or anyone else in the jury reached out to other jurors to see if they'd like to issue a public statement and ask to be polled by Judge Canoni? He says, last I spoke with you, I said I should speak to the group, but then I thought I should retain legal counsel first. Nobody has suggested it yet. Individuals have done it on their own with other media, but I think the best way is a unified front. So it's interesting that he wants to get an attorney first. But that's good. Um, the entire group should reach out and say, as a unified group, that we, the jury, agreed on counts 1 and 3, whether that means an affidavit or sworn testimony in court. We should clarify that we weren't clear from the directions that we could acquit on the 2 counts and hang on the third. So he says he wants to clarify that that they weren't, he wants to make note that that was not clear on how they could do that because Judge Canoni did not give them jury instructions for someone with multiple counts, just jury instructions for a single count. All right, so Turtleboy asks, so long story short, you're still thinking about it, but want to talk to a lawyer first. He says, I want to go to the group, and if it's not successful, then I would probably go and reach out to one of the court officers to let them know that was our vote. And to clarify, you are not one of the voters who reached out to the defense already. I was not. So again, that is now, he is the sixth person to confirm that they acquitted her on 2 charges. Yet Judge Canoni doesn't want to hear it. Wrapping this up here, do you know what other jobs people had on the jury? I know there was an engineer, a lawyer, an EMT, meaning him, a nurse, a mailman, and a physician's assistant. Seems like an educated jury. He says it was an educated jury. One person was a financial planner, I think. One was a retired teacher. I'm not sure what everyone else did. He says, how did you stay awake when Adam Lally droned on with his ridiculous questions? He says, we drank a lot of coffee and Coke. When Lolly came up with all those pieces of taillight and entered each of them into evidence, it was tough. I bet. There were like 45 pieces of taillight. To end this, I'm going to go through a number of questions. It's going to just be like lightning round. So tell me whether each one of them was discussed by jurors during deliberations. He says, okay, hair on the car. So the question is, were any of these topics discussed by the jury? And it's a yes or no. The hair on the car. He says yes. Glass on the bumper. Yes. Nicholas Barrow's testimony. Yes. John's Apple Health data showing him going up 3 flights of stairs. Yes. The 227 Google search. Yes. The 911 call and how Jennifer McCabe sounded. So odd. Yes. The dash cam videos. Yes. Katie McLaughlin's association with the Albert family. Not really, a little bit, but not significant. They probably forgot about her because it was so long ago and it was a 10-week trial, 9-week trial, so they forgot about her. What about Michael Proctor's association with the Albert family? Not really. So the lead investigator, who is under investigation for his relations with the Albert family and his conduct during this investigation, you didn't talk about his close relationship with the Albert family. And the fact that, oh, he was getting bribes, gifts from the Alberts, from Julie Albert, who texted him and said she wanted to get them something or whatever. He said, get it for my wife. Um, so they're getting bribes, they're close family. His own mother had called them their second family, the Alberts. So how did they not talk about this? It's the lead investigator. I'm so confused why that was not a bigger topic of conversation. All right, moving on. Brian Tully's involvement with the CERT team search. Because remember, he told them exactly where to search and like side by side. They did this tiny little area, searched, got their pieces, and left after a half hour. Brian Tully's involvement in the search? No. Names of officers involved in the CERT team search. A little, but stopped after looking at the video showing how long it would have taken the car to get to the Canton police. I don't know what that means. Stopped after looking at the video showing how long it would have taken the car to get to Canton police. I don't know what he means by that. Brian Higgins' white Jeep, which some witnesses said was there and others didn't. They said no, they didn't talk about Brian Higgins' Jeep, Brian Higgins' behavior and whereabouts that night after leaving the Alberts' house. Barely. Brian Albert not coming out of the house. We didn't think twice about it. Why? Everyone on the planet who hears about this case is like, the homeowner didn't come out? He didn't come out of the house? Shows consciousness of guilt. He was avoiding it. He was hiding from it. Jennifer McCabe's two phone calls to Nicole Albert that came up as answered on Cell Bright. He says no. So remember, right after she called 911, she called her sister Nicole, and both calls were about just a few seconds. You can actually kind of hear her talking something about like coming out, or are you coming out, or coming out to help, something like that, while she's talking to her sister on the phone. That's in the recording that was on John's voicemail when the 911 call. We only hear the Jennifer McCabe side of the 911 call because it was John's voicemail had picked up on Karen's phone. All right, so the Ford Edge Lucky Loughran said he saw briefly but not extensively because it was dismissed as a distractor. What? So exactly in the spot where John was, the tow truck driver, I'm sorry, the plow driver, snow plower, uh, he said there was a car exactly where the body was found hours later. But that's just a distraction? I'm so confused by that. How is that it's a distraction, guys. Don't be distracted by the Ford Edge that's hiding the people moving the body to the lawn. Kristen Morris's sudden decision to pick up Caitlin Albert despite having to go out plowing at 3 a.m. They did not discuss it. Nope. The amount of alcohol Karen Reed consumed. Yes. In closing, Turtleboy concludes, it's just wild to me how we've spent 8 months analyzing every aspect of this case, and ultimately the people tasked with deciding Karen Reed's fate completely disregarded everything that had to do with the McAlberts. Which is why I believe there's a McAlbert plant on the jury. So that they could have led conversations back to, well, Karen drank this many drinks and Karen did this. And, anytime they start talking about the McAlberts, a McAlbert plant would be like, yeah, but Karen, did you see Karen did this? Karen didn't take her shoes off in the house. It was snowing. John didn't allow shoes in his house. Um, But at least Karen Reed's defense team can use this information to pick a better jury next time and alter their strategy for trial too. So, I mean, these interviews that Turtle Boy does are invaluable. I mean, so much information that could be taken from this that Karen's defense team and the Commonwealth can learn from and improve their case going forward. I mean, Commonwealth can't really improve much of nothing, but they can still improve the streamline, let's say streamline their proceedings. So I don't know. I think it was a really interesting interview, and I'm glad that we have. So now, okay, I just want to point out the 12 jurors who acquitted Karen. Um, Many of them have come out either to the defense or to the media, meaning Turtle Boy. So some have gone to Christina Rex with, oh, I can't remember, WVZB or it's something. It's all those letters in some fashion, I think. Christina Rex is a reporter locally, and they've gone to her, and she's posted things on X about what they've said to her. So she's the only other member of the media that we know of that the jurors have gone to. And that was really only to confirm that, yes, we did acquit her. Somebody came out and said to, like, Christina Rex, like, we did. Why is Canoni not calling us? Like, hello. That was kind of the quote. So, yeah, so one person went to Christina Rex, and we've got now two jurors who have gone to Turtle Boy. So, what does that tell you about mainstream media? That they trust Turtle Boy, a blogger, just a blogger, to handle writing this because they feel like he would be the most just and fair in reporting it. I don't know why I'm hearing my neighbors yelling or something. All right, sorry. All right, so and lastly, I just wanted to close up with reading up on Kevin Albert and his whatever his punishment is for leaving his badge and his gun after a night of drinking with Trooper Proctor. He left them unattended and didn't know where they were. And Trooper Proctor was also drinking and in his cruiser at the time. So, yeah, this came out at trial. The day after this came out, Kevin Albert was put on administrative leave, paid leave. You just got a paid vacation for the summer, is basically what happened here. So let's read about this. So this is Canton Cover-Up Part 401 by Turtleboy. Kevin Albert got a 3-month paid vacation for getting drunk and leaving his gun and badge in Michael Proctor's police car. And this is Kevin. This right here is um, Mike Loughran, I think. I think he's the brother, or he's related to Brian Loughran, the plow driver, Lucky Loughran. So it's interesting. They're kind of on different sides. He is the Canton Select Board chair or whatever his title is. I have no idea. All right, so on Tuesday, the Canton Board of Selectmen held their 4th straight bi-monthly meeting virtually instead of in person due to the fact that they don't like getting roasted and berated by middle-aged women during the public comment portion of the meeting. By having the meeting on Zoom, there is no way for them to clarify whether or not the people speaking are actually Canton residents. So now they've just put their select board meetings on Zoom, and anybody who has a full name can be given the floor to ask some questions or comments. So luckily, one lifelong Canton resident named Wade Hunter was able to speak and suggested building a monument to Turtleboy after berating the police department for their bungling of the homicide of John O'Keefe and Sandra Birchmore. So I'm going to actually play this because it's pretty funny. So this is Wade Hunter, aka maybe someone we know who has a blog. Let's see if it plays.
There you go. State your name and your town, please.
Yeah, this is Wade Hunter from Canton. And I was just reading on this website, the Turtleboy Daily News, a really sharp guy. Just about, there was a juror that he interviewed, and his juror said that the Canton Police Department are like a joke, and that they were such a joke that they assumed that they were incompetent, and they didn't find no pieces of taillight. You got that? No pieces of taillight at the scene, right? But they missed it all. But the state police found 45 pieces. And so instead of assuming that the pieces were planted, they assumed that the Canton Police Department, led by Lieutenant Gallagher, he's just blind. You got that? He's just blind. He don't see nothing. How do you employ all these cops and pay them all this money and they can't even find no?
Sit down, Mr. Lolly, says LMAO. She's laughing her ass off.
Thinking taillight. Oh, and by the way, how come the chief hasn't said nothing about that? How come she hasn't stood up and say, hey, state police, my cops, they can see stuff. We ain't stupid. There was no taillight there when we were looking, but now the state police and Michael Proctor comes along and there's all this dang taillight there. Oh, and speaking of the chief, where is she? Is she going to say anything about Sandra Birchmore? Hello? I thought you were supposed to be this girl power. You're the first chief and blah, 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 blah. Girl power up the yin yang. How come she don't say nothing when a pregnant girl is killed in the town and Lanka shows up? Of course, Lanka's the first one on the scene. And what does he rule? Oh, she's a suicide. You don't even look around the apartment. He sees there's a broken necklace on the floor. He didn't think that was a clue. He thought there's laundry. There's laundry in the washer and dryer. He doesn't think that's suspicious. And what happens to Lanka? Oh, Lanka got a promotion for that. Every time Lanka covers for one of his scumbag McAlbert friends, it seems like he gets yet another promotion. And I know Chicken Palm Charlie's sitting there right now drinking his iced coffee.
These comments are hilarious. If you're listening, if you're watching, it's like, amazing, go get him. Is that Turtleboy? And the names too is like mediocre parm, mediocre chicken parm is like somebody's name too. Like it's hilarious if you're reading the comments
At
here.
home, and it's all his fault. All the corruption in this town stinks. I've been living here my whole life, and thank God for Turtleboy for shedding the light on this stuff. We should build a monument to Turtleboy in this town because he's exposed all you corrupt scumbags one by one. Thank you.
He should have ended it bang bang. But yeah, oh gosh, that was quite embarrassing, I'm sure, for Mike Laughlin. And I bet you the next Canton Select Board meeting, however you say it, Canton Select Board, yeah, the next meeting, they're gonna probably cut off public commentary because Turtle Boy got him and got him good. So they're not gonna like that, and they're gonna be like, you know what, you guys just don't have a word to say now or a platform. They're not gonna give him a platform anymore, I think, because they're sick and tired of getting embarrassed. If being in person didn't make it stop, you know, Zoom meetings definitely not going to. Anyways, all right. So moving on with the article, Turtle Boy says that guy made some great points. Why doesn't Helena Rafferty stick up for her officers? The juror I spoke with said that the jury was operating under the assumption that Canton police didn't find any taillight because they were blind and incompetent. How is it okay with the fact How is she okay with the fact that this is what their reputation is now? The primary reason people believe that is because the state police found 45 pieces of taillight that CPD missed. Isn't it in the best interest of her officers to clear the record and loudly proclaim that those pieces of taillight were not there when her officers searched the scene? I mean, right? Right? Wouldn't you want the world to know, like, hey, my guys aren't that incompetent? And why hasn't Chief Rafferty said a word about the pregnant woman who had her life taken in her town, the town of Canton, 4 years ago? Her officers concluded that Sandra Birchmore took her own life despite a broken necklace and thousands of text messages that would lead anyone with a brain to suspect Matthew Farwell was her perpetrator. Rafferty bragged about being the first female chief of police in Canton, yet she did nothing, as her male officers allowed a pregnant woman to be groomed, abused, and her life taken by another cop. Some have said that Wade Hunter might not be from Canton, but if the board wasn't full of cowards who were afraid to have meetings in public, there would be no dispute. The board also announced that Kevin Albert was disciplined after an investigation that began in June. So, Canton Police Detective Kevin Albert, placed on paid administrative leave in June, faces additional discipline following an investigation into misconduct allegations. They didn't say what that discipline was or what the results of the investigation were. All we know is that they were started after Michael Proctor's text messages revealed that Detective Albert got drunk on the Cape while supposedly working on a case and left his gun and badge in the disgraced state trooper Michael Proctor's work vehicle. The text also confirms that Albert acted as a liaison between the witnesses and state police, offering to set up interviews inside CPD headquarters despite the fact that CPD was self-inflicted off of the John O'Keefe case specifically because of his familial relation to the homeowner whose front lawn John's body was found on. And this is a text message that says Paul G, so Paul Gallagher, is reviewing the reports now. This is from Kevin Albert. Steve Seraf is here if you need to interview him, and we can call Stephen Mullaney as well. So he is setting up and arranging interviews for witnesses in this case to Trooper Proctor. Proctor says, okay, great. Yuri and I are coming in at 1 to interview a firefighter, Katie McLaughlin. It doesn't say that, but that is, oh, and it does. It says Katie underneath. And then this is another text string where Kevin says, it's bad. I was hungover for sure today. Couple tonight to make me feel good. And then Proctor says, a couple of those is all it will take to right the ship. So this is when he drank too much and left his badge in Trooper Proctor's car. So apparently he needed a little hair of the dog to feel better that morning. All right, so multiple people have seen Kevin Albert working details as he tries to catch up with Lieutenant Paul Gallagher, who earned more than $300,000 last year. He's the highest paid officer in Canton. Over $300,000 he made last year. And he's retiring now too, which suddenly he's just retiring after this Karen Reed thing. So that's interesting. I don't know if it has anything to do with it, but it just, a lot of people have retired after this case unfolded. It appears as if Albert's discipline for inserting himself into a homicide investigation that he wasn't allowed to insert himself into, and for losing his gun and badge in a drunken bender, was a 3-month paid summer vacation. Lucky for him. A normal police department would care about the optics of employing someone like Kevin Albert, but the Canton Police Department is not a normal police department. And run 'em down, Rafferty. She has her own legal battles that she's dealing with because she hit a pedestrian with her car, just driving along. Rafferty is a hack chief who is allowed this this clown show to fester. He's saying so. She's part of the reason all this is going down. She's allowed her officers to continually act in ways that would be considered misconduct. Any officer who drinks on the job and leaves a badge and gun in someone else's car can't find them the next morning. I would think that that's a fireable offense. But it really takes a lot, apparently, to get fired if you're a cop. Like a lot. And it's just horrific going back to Enrique Delgado Garcia. There's going to have to be some ramifications. Like, there's got to be an internal investigation into that to see who did what to him because his injuries certainly were not sustained by himself. He didn't just fall and all those things happened to him. Somebody did that, like in Olivia's post. Somebody caused those injuries on him, and those the somebody or somebody's who it was need to be held accountable, and the people that employ them and oversee them need to be held accountable because it needs to go all the way up the chain. It can't just be, let's fix it with a band-aid. Let's just take Triple Proctor out and, fire him. No, it's got to be a full-on cohesive plan to get all of these officers out. And I think the feds might be working on something along those lines, but I don't think they're going necessarily for like a Kevin Albert. So that's on Chief Rafferty to make sure that he is punished appropriately. Can you imagine being a Canton resident and being pulled over by a Kevin Albert? and then you have no respect for that person, and you're like, I'm supposed to listen to you? You lose your gun and badge while you're on the job, working a case at the Cape, drinking with Proctor. Why should I listen to you? What I did, I just sped a little. You drink and lose your badge all over town. So it's very hard to respect and um, abide by law enforcement when you know that they are when you know that they do these kinds of things. You just can't respect them, and with that respect, without that respect, then they're just a regular citizen almost. But that gives us a problem because if he still has the power to put you away and take your freedoms. So I feel bad for the people of Canton. I really do. And they have that with a lot of people in that area now. Like all of their law enforcement, they don't trust. With Rita Lombardi and the others who are getting their lawns trashed, they don't trust law enforcement. They haven't they went straight to the FBI about it because they don't trust the law enforcement in Canton to do anything. So, and not like the FBI is going to do anything, but hopefully eventually some indictments start coming down for the McAlberts, and then some of this craziness might stop, hopefully. And we need to see not just the McAlberts, but we need to see accountability for all of the law enforcement that was involved in this, and in Sandra Birchmore, and in many others. I can go on. There's Justin Root, Sean Ellis. Um, the list goes on. There's so many that we need to fight for justice for. So, especially in Massachusetts. I'm not even from there, and I feel like I am with you guys in spirit. So, thank you guys so much for watching. Let me know what you think in the comments below, and I will see you guys in the next one. Take care, everybody. Bye now.